uMkhonto weSizwe party is trying to block the National Assembly's first sitting. Now, the party has filed an application to that effect at the Constitutional Court. South Africa's newly elected National Assembly is due to convene on Friday for the swearing in of lawmakers, elected speaker, as well as deputy speaker and the country's president. So for more on this, let's also discuss some other related stories. We welcome in our studio SABC News reporter Canny Maphanga. Canny, good morning. Thanks for joining us at this hour. We're seeing developments unfold minute by minute as we edge closer to Friday. Perhaps you could give us context as to what is transpiring, and also the application or interdict that obviously has now come to the fore, trying to interdict the sitting of the first sitting of Parliament.
Well, absolutely, Liesl. Another day, another court challenge by the newly formed MK party. What they've done is they filed an application in the Constitutional Court. It's in two parts, Part A and Part B. Really, the relevance of what we're dealing with now is Part A, in which they're trying to seek an interdict, an order which would stop the convening of the first sitting of the National Assembly, which we know will take place on Friday at 10 a.m. in Cape Town. Now, what they're basing this application on is on Section 46 of the Constitution, which deals with the composition of the National Assembly. And it's really, if you look at it, perhaps maybe others will have a different interpretation, but it really is about the composition in terms of the electoral system. So ensuring that it doesn't constitute no less than 350 or 400 members. So it is on that basis that they are filing to say that that sitting cannot continue without their 58 being there. Now, you may remember that when we had those hotly contested elections, there were a number of challenges, not just from the MK party, but a lot of parties had listed their objections. And we know that in those 48 hours that we saw leading up to the Sunday declaration, that the IEC was trying to resolve some of those challenges. And we know that some political parties were able to get some of the resolve that they wanted. Because remember, when you look at those objections and those challenges, you have to look at them as if, are they material? Would it have made a significant difference in the results that that political party saw? So, for example, if it said 5,000 on the leaderboard and you were short of 2,000, was that going to make a difference? Would you have been able to obtain the seats? I mean, that's how you look at the material objections that were put there. Now, we know that there were hundreds of objections by the MK party. We know that they had that briefing at the Rock, where they stated that they didn't want those results to be declared. The results were declared on Sunday at the Rock, and they were declared to be free and fair, those elections. So from the second, you would have known that that 14 days is what legislation gives for the first sitting to take place at a date and time to be determined by the Chief Justice. And we know already that he has determined it to be Friday the 14th of June. So in the absence of any court order which nullifies what's going to take place on Friday or stops what's going to take place on Friday, those officers, that is the Secretary of Parliament, the Chief Justice, and of course the Judge Presidents that are going to be presiding over the various first sittings of the provincial legislatures, the swearing in of those members as well, have to continue with that work in terms of the legislation.
All right, thank you for painting that picture. Section 53 also comes to the fore. The MK party had the view that there cannot be a sitting because of their 58 seats. They will obviously not be there because they will not be present. Unpack that a little bit further for us as well.
Well, Section 53 deals with decisions emanating from the National Assembly and states that for that to take place, you need about 1/3. So it places a quorum for those decisions to be at 133 members that need to be present. So we know that on Friday, upon confirmation by the Chief Justice, that there will be an election of a speaker, deputy speaker, and the president following the swearing in of the members on Friday. So the assumption that you may not proceed with what the business of the day is on Friday may not be entirely correct.
All right, and then Canny, I know that this was discussed, yesterday as well, but the timing of all of this, and given, the time that the Constitution has to afford this to matter, talk to us about the realities on the ground at this point.
Well, the Constitutional Court, urgency might be a bit relative there.
Sure.
So we are a bit 2 days ahead of that sitting. It's unlikely. I can't see a scenario where they'll be able to come up with an order or deal with the substantive issues there. We know in the papers there's a Part A and a Part B, and we know in the Part B they allege that there were substantive issues, they allege vote rigging, and that you can't convene that sitting prior to those issues being resolved. However, quite interestingly, in the Part B, or the merits of what they're arguing, they've chosen not to include that evidence at that stage. So I don't know if the Constitutional Court will be able to deal with it that quickly within 2 days, but we'll continue to monitor the scenario or the various courts until leading up to Friday. And in the absence of any court order, the viewers, the nation can expect that the Chief Justice who is presiding over that first sitting will continue with the business of the day.
Well, Canny, you said another day, another case. We'll monitor those developments. Thanks for painting that picture for us at this hour. Canny Maphanga, of course, our reporter.